Welcome back to Court TV Live. We are going to get you back inside of that Washington State courtroom soon, but we have some breaking news out of Idaho where Bryan Kohberger is now in court today ahead of his sentencing that we are expecting to happen next week.
Kohberger, who pled guilty earlier this month to murdering 4 University of Idaho students back in 2022, is back in court today where the judge is hearing arguments over lifting the gag order that is in place in this case. Let's listen in just for a moment.
The counsel or others who were previously bound by it to speak, and the state has indicated that they don't intend to until after the sentencing. And certainly I would hope that the media interests would respect those positions and give people the space that they need and request. In terms of, for example, the defendant's family and others coming and going at the sentencing, we intend to have, as we did before, appropriate security measures in place to ensure that they, as well as the victims, are allowed to get in and out unscathed by the media, if that's what they wish to do, or if they wish to speak to the media, they can do that as well. At this point, I just don't think that I can justify the continuation of the non-dissemination order. I think the rights of the public to information in this case is paramount, given the fact that a plea has been entered in this case, and so I'm going to lift the non-dissemination order. But I want to point out what that means and what it doesn't mean. So obviously nobody's required to speak to the media, first of all. Second of all, I want to be clear that the court's prior preservation order to the parties is not lifted and continues to stay in place. And so it's important to understand that those obligations still exist. And then the other thing I want to point out is that by lifting the non-dissemination order, that does not convert sealed documents to unsealed documents. Documents previously sealed by the court are still sealed. Now, I see the media also filed a petition to be heard to unseal everything. I'm denying that outright. The request to intervene, because I think it's premature at this point. So the court will its intent is to, after sentencing, begin the process of reviewing all the sealed material in this case to determine what should be unsealed and what should not be unsealed. That process will include an opportunity for counsel to register any objections to unsealing documents, specific documents, and request to redact certain sealed documents before they are unsealed, or unseal them in a redacted form. I intend to do that in groupings of documents at a time. As I sit here now, my thought is I'm going to start from newest to oldest, because those are the ones that I have the most working knowledge of as to the reason for the sealing of the documents, as well as the content of those documents. And so I think I can get through those more quickly. As we move backward in time, it's going to take further, more extensive review by the court to figure out to obviously review the content of those documents, listen to those hearings, et cetera, and determine why they were sealed and whether that rationale still is necessary, or that rationale still requires the documents to maintain that sealed status. And so before everybody gets out their pen and paper and sends in public records requests, understand those will be denied for sealed records until they are unsealed, and that process is going to take time. And I'm not talking days, I'm probably not talking weeks.
Okay, there you have it. The non-dissemination order being lifted will be lifted, meaning that the people that were required not to say a word can now speak if they are willing. Judge Hippler mentioning that the state does not intend to say a word until
Sure.
after next week's sentencing.
But the sealing of certain records, 168 orders for sealing had happened in this case, which is excessive compared to a lot of other cases, but that is going to remain in place until the judge looks into that more.
Jack Rice with us. Let's start with the plea deal. The prosecutor, Thompson, entered into this. Some of the families are all in, others are adamantly against this plea deal, which spares Kohberger's life. He doesn't get any appeals. What's your overall thought on that process when you put your prosecutor hat on? What goes into that, and what do you think of it?
Well, a big part of it is certainty. What you get is a saving of the next 20 years of appeals. And what you get is you never know. There were some interesting aspects in terms of some of the rulings in this case, some of the evidence that potentially could have been introduced, what happened with the DNA that was found from his father in Pennsylvania, how that was actually extracted and used and then tested, I think, down in Texas, and whether or not that could actually come in, or if it did, was it appropriate? All of those issues could have gone up on appeal, and to avoid that and to get the certainty of it is one of the things that I think this community wanted collectively. But of course, there are going to be some people who are absolutely outraged by it. And you do have to listen to the victims and the victims' families. At the same time, they can't be beholden and be shackled by what they always want. And in this case, it was split. Some wanted it, some didn't. This was a very hard decision from a prosecutorial standpoint.
Oh, yeah. And when we're seeing him, Jack, there in those prison clothes, that is how we are going to see him going forward. He is not going to be able to be in civilian clothes, a shirt and tie. He's going to be in his jail garb, even at that sentencing that's happening next week. Ted, you'll be there.
Yes, it will, and it'll be his last court appearance, theoretically, as long as he is not accused of other crimes, next week when he appears in court for the final sentencing. We'll get a break. Thanks to Jack Rice. Back after this.
Welcome back to Court TV Live. I'm Julia Janae, along with Ted Rollins. We are continuing our coverage out of Idaho, where a motions hearing is underway in the case against Bryan Kohberger.
He, of course, pled guilty to killing the 4 University of Idaho students. He's back in court today as the judge is hearing arguments over whether or not to lift a gag order, which he is doing in part in this criminal case due to the notoriety of the murders. Almost all the information related to the case has been locked behind that gag order, and specifically the inability for anybody to discuss the case. If you are associated with the case at all, the judge early on said nobody is talking until this thing is over. Well, now we're getting to the end, and in anticipation of next week's final hearing in this case, and that is the actual sentencing, the judge is lifting the dissemination portion of the gag order, which would allow potentially people coming into the courthouse to answer a question or two if they wanted to.
Yeah, and it makes sense because there's no jury now to potentially prejudice in any way. There's no jury pool to taint. So now it's just up to the judge to approve this sentence.
And up to the people if they wanted to speak or not, which the prosecutor's office, apparently, according to the judge, and it sounds like law enforcement, they've already alerted the court that they do not plan to do any speaking until the conclusion of next week's hearing, which makes sense.
And let's get you back inside the courtroom, picking it up where we left off with the judge speaking to these parties.
Would be essentially inappropriate to unseal, including protection of individuals from undue harassment, et cetera. And so that's just going to take time. In addition, I'm unlikely to unseal much until after sentencing and after the appeals period has run. Now, I recognize the plea agreement includes a waiver of the right to appeal, but as the parties probably know, the U.S. Supreme Court in Garza versus Idaho has indicated the fact that a defendant waives the right to appeal doesn't mean they don't have the right to appeal. And so it may affect the outcome of that appeal, and it may affect the underlying case and the plea agreement. But nonetheless, the right to appeal does not go away because of the waiver. And so I think it's important for that time period to also play itself out to see that it goes the way that I think people intend and expect it to. And so I will be entering an order in the next week or so outlining the process for the review of the sealed records. Counsel will need to maintain a presence in the case in order to review those materials as they are proposed to be unsealed by the court. You know, because the timeline that I will likely give you will not be, I suspect, extensive as for each group of records. So I might give you 14 days, for example, to provide a response as to a group of, you know, a dozen or a couple dozen records at a time. So just sort of heads up and fair play with respect to that. Any questions by the parties about the ruling today?
Not from the state, Your Honor. Thank you.
No questions from the defense. Thank you.
Ms. Olson, do you have any questions?
I do, Your Honor. I wasn't certain if I was included within the parties. I would just say I think that the court's proposed manner of moving forward on the sealed records will likely largely address our interests, and we appreciate the court setting that out in this hearing today.
Yeah. If certain records after review maintain their sealed status, it would be at that point that I would entertain requests for me to consider that more formally and to have a voice in that. But I think until I've gone through that process, it's premature, which is why I don't intend to take up your motion, your more recent filed motion at this time. So,
Thank you, Your Honor. We appreciate that.
All right. And with that, then we are adjourned. Thank you. I'll see you next week.
Thank you, Your Honor.
And that wraps up that quick hearing there in Idaho ahead of the sentencing that we are all anticipating next week.